situation? Do you see a higher rate of discipline between those who graduate from the diploma privilege versus those who took the Wisconsin bar exam? And I will have to tell you, and I've just confirmed this with our Office of Lawyer Regulation once again, that we do not see any kind of increase in the number of people who are disciplined, who are diploma privilege graduates versus those who come in by another mechanism. And what would that be anyway? Presumably that would be competency. And there are far more issues attributable to other matters. And I've identified some of those here, such as business acumen, interpersonal skills, financial pressures, alcohol and drug addictions, mental health, etc. And to the extent that competency does play a factor in discipline, it's very, very low, and it's typically less than 1%. Next slide, please. A number of years ago, back in 2007, there was a gentleman by the name of Christopher Weissmuller, who was a student at the Oklahoma City University School of Law, who filed a Section 1983 claim against the Wisconsin Board of Bar Examiners and the Wisconsin Supreme Court. In his suit, he asserted that the Wisconsin diploma privilege discriminated against interstate commerce because it afforded a privilege in lieu of a bar exam only to those individuals who graduated from one of our law schools. This case did go to the Seventh Circuit twice, and ultimately it was settled in March of 2010. So shortly after my arrival at the BBE, and to be candid, I wasn't very involved with that case, other than until at the very tail end of it. So that is the only case during the last 10 years that the privilege has been at issue. Next slide, please. I heard a tail bit of this with the last speaker and wanted to touch on it as well, reciprocity and what that might mean. So in Wisconsin, we don't actually have direct reciprocity with any jurisdiction, meaning we don't have identical requirements or an agreement with another jurisdiction. What we do have is proof of practice elsewhere, which allows you to come in if you've practiced 3 out of the last 5 years. And what I can tell you is that under a proof of practice provision, all we're looking at is the practice experience. Obviously, we do a character and fitness investigation as well, but it's years of practice. And we don't take into account whether you took a bar exam or whether you didn't take a bar exam. But I can tell you that there are some states that do not accept the diploma privilege and do insist that you take and complete and pass, obviously, a bar exam in order to be eligible for admission in those jurisdictions. And so it does remain, admittedly, a bit of a conundrum, because obviously if our folks aren't accepted just solely based on the privilege, they're going to have to take and complete the bar exam. I think in some jurisdictions, despite the number of years of practice experience they do have. So the NCBE, by the way, the National Conference of Bar Examiners, has a chart that identifies those states that don't accept the privilege in its guide to admission requirements. So anybody interested in taking a look at that might want to do so to kind of get a sense of how that plays out in practice. Next slide, please. So these are some final thoughts that while preparing for this, I discovered in a law review article written by a professor at the University of Wisconsin, who noted that as someone who has graded the bar exam, she can tell you that an essay that would pass for bar exam purposes would fail if submitted to a UW Law School course. She notes that she's much more likely to fail a Wisconsin law student because she knows that there's no bar exam to do the job for her. And finally, and I thought a bit interestingly, bar exams force students into those classes covered by the exam, but none which are skills oriented. So the bar exams tend to make students less prepared for practice by emphasizing, the doctrinal subjects rather than the clinical skills. Next slide, please. Next slide, please. I'm happy to answer any questions that you may have at this point.
Thank you very much. Are there any questions? I see Jeremy has a question.
Hi, thank you, Justice. I had a quick question. One of the issues that I've kind of come across, and I think maybe some other folks have too, is this idea of law school admissions, right? So we're talking about diploma privilege based on where you're going to school and the law school and that sort of thing. And I know one of the issues, and this might not be something we can flag now, but maybe discuss later, but this idea of, what it sort of seems to me that the data suggests that there is an effect on law school admissions when it comes to diversity and education. And it sort of seems to me also that sort of higher ranked law schools seem to admit generally less diverse candidates, but then on the alternative point, higher ranked law schools generally graduate or have graduates that have a higher percentage of passing the bar. And so I'm kind of curious if you've had any data on that in terms of the effect of where somebody goes to law school and how that should be determined by whether there's diploma privilege or whether there's an exam, that sort of thing. Hopefully that question's not too broad, but something that came across as I was listening to your presentation. Thank you.
Are you asking me how many people who take the Wisconsin bar exam, where they come from and how they do? Is that what you're wondering?
Right. Yeah. If we could be more specific about it. Yeah, that would. Yeah. Do you have any data on that?
We do have data on where bar examinees where they graduate, certainly, and we certainly do. I mean, we certainly could compile statistics that demonstrate if you go to the University of Minnesota, for instance, how many people pass versus how many people pass from, I don't know, the University of Illinois. Yes, we certainly have those statistics. Yes.
Okay.
I'm not sure how that connects with the diploma privilege exactly. I'm not sure I'm understanding your question.
Sure. So if you have, so we're talking about the state of Wisconsin, right? So if you graduate from an ABA accredited school, you're allowed diploma privilege. That's pretty much the rule, right?
No, you misunderstand. The only two schools that are eligible for the Wisconsin diploma privilege are Marquette and the University of Wisconsin Law Schools. So the students who graduate from those two law schools, if they take and complete the required credits, they then become eligible for the privilege when they apply.
Okay. So is there more than two ABA accredited law schools in the state of Wisconsin beyond Marquette and Wisconsin?
There are not. We only have the two law schools in Wisconsin.
Okay.
Thank you for that. Thank you for the clarification. Neil?
Just to sort of follow up on that last point, why doesn't Wisconsin, or I guess the Supreme Court of Wisconsin, allow in graduates from other law schools besides the 2 law schools in Wisconsin, assuming that they can show that they meet the same credit requirements under the rules?
I think the primary reason behind it is that, or one of the primary reasons behind it is that the students who attend the University of Wisconsin and Marquette undergo, a lot of classwork that addresses Wisconsin law. And so those people who go to schools out of Wisconsin are not typically going to be addressing the same sort of substantive material in their coursework that they otherwise would here in our state.
Okay. Thanks.
Thank you, Neil. Are there any other questions? Donna?
Yeah, just one quick question. Just because we've got 50 plus law schools in California, as compared to the couple of law schools that you have. So I'm curious how much back and forth and give and take you had to engage in to get agreement on the curricular requirements.
So those curriculum requirements have been in effect since the early 1970s. And at that time, I certainly was far too young to be participating in the back and forth related to that. And it's an interesting question, but I don't honestly know. If there was a lot of back and forth on it, I'm not aware of that. My guess is that these are pretty fundamental core courses, and so there probably wasn't. But to be fair, I that might not be accurate. I really don't know. I mean, I could certainly ask around for faculty who might have been at either one of the law schools at that time and see if they have any insights, or ask a couple of our justices who may have had some awareness of it.
But it would seem if there was in recent years, it sounds like it's not like the law schools have been reaching out to you to request changes to the curricular requirements.
No, they haven't. And in fact, our Board of Bar Examiners annually meets with our court, typically in December. And a couple of years ago, we broached that topic with them and said, do you think it's time for us to look at that once again and see whether or not any changes should be made to it? And it was interesting. It really didn't get a lot of traction at that time. So it's pretty much been the status quo for quite a while now.
Yeah, I thank you. I think what I'm getting at, and for whatever reason, I have not been asking directly, but the direct question really is how contingent is having a successful diploma privilege program on having a really strong relationship with the law schools and your confidence in the curriculum that the quality of the curriculum that they are delivering?
I think unquestionably it helps having only 2 law schools. I mean, I don't think you can really argue with that, right? I mean, you in California are facing a really different situation. You've got 50 schools, some of which are accredited, some of which aren't. And if I were in your shoes, I would need to feel pretty confident that whatever is being taught and how it's being taught and by whom it's being taught would have to be, there'd have to be a base level, right? So that you could be assured that the same information and the same quality was being provided across the board. And I do think that level of assurance exists with our law schools, with the deans, with the faculty, with the court. And I think, so many of us are graduates of those schools that we know what happens and how it happens and with whom it happens. And you really do face a different situation, because you have far more people you'd be having to deal with about it.
Thank you very much.
It's,
I really
I mean,
appreciate it.
you know, I don't know that it means it can't be done, but it's just, I don't know collectively whether or not you would feel that the same level of confidence that we typically do here. I just don't know.
Are you aware of any other states that have made serious efforts to try to replicate this program?
You know, a number of years ago, Kentucky invited me to speak to them, and I went down and met with several members of their court, and they had you know, not an identical panel to what you've got here, but similar, and they had far fewer law schools than you do, I should say, and I think their concern was similar. Too, that they just weren't sure given the number of schools, and they don't. I think they have under 10, but they declined to adopt it there too. But I mean, it is interesting to me because at one time, you know, there were 32 states that did it. So certainly out of those 32, there surely would have been more than 2 per state. But to be fair, I don't have all of that background information at my fingertips.
Thank you. Are there any further questions for Jacqueline?
I do have one more slide.
Okay. Thank you.
I do invite you all to come visit the Badger State. We have wonderful things here to offer you, and I would love to host you here in Madison. So if the opportunity ever presents itself, I certainly would love to see you out here.
Thank you. I love that slide, and we do have one more question. I'll call on Amy, please.
Yes, thank you. I humbly accept your invitation when we go to the shareholders meeting next year for the Green Bay Packers.
Oh, well, welcome to Green Bay, where many of us are big Packer fans. And that's weird because you see the football, but the Packers jersey isn't actually up there.
Okay, well, thank you. I hope to make it out there too. I appreciate you spending some time with us here today.
Well, thank you again for inviting me. And I will be candidly tell you, I'm really curious to see what decisions you ultimately reach.
Thank you. I appreciate it. Bye-bye.
Bye-bye.
Thank you. It is now 4:12, and I wanted to circle back just to get closure on the questions that were outstanding, and then we can talk a little bit about the next steps going forward from here. But if there are still questions, I would like to address them. I believe Leah and Tracy had questions on the pros and cons document, and Leah and Ryan had questions on the guiding principles document. So if you're still here and have questions, it's like Ryan, I'll start with you.
Yes. So I believe it was Mr. Jeremy Evans, I think. Yes, Jeremy Evans suggested that we include civility in our mission statement. And I stand firmly behind that. I want to note that I've even heard our Chief Justice multiple times mention civility in public speaking engagements. It's been added as part of the oath that new attorneys make when they enter the profession. And just as the former judge from New York said, when we start incorporating things into the bar exam, it becomes a focal point in law school education. And when law students are shown how to respond to issues of civility, what their options are and what they should do, I think it arms them with that skill set when they do go into the profession and they're dealing with a nasty attorney, to not fall into that and to be above it and respond in a professional way. Not only that, but imagine if you're not an attorney and you're watching attorneys behave in this manner, it just undermines the rule of law and confidence in the profession. So we need to be really sensitive about that. Thank you.
Thank you. I agree with that. And I think Tracy had another question. I'm not sure if you wanted to actually respond to something that might have touched on an area that you had previously discussed, or if you even remember at this point.
I think I remember. It's just a clarification. But did I hear Donna mention and also read somewhere that on the UBE that there's multiple passing scores that are used? States adopt different passing scores.
Yes. So the setting of the pass line is at the and David, please correct me if I'm wrong, but setting of the pass line is at the discretion of the individual states. And so I think there's sort of I think a lot of states sort of coalesce around a certain number, but there are differences even among those who are UBE states, as I understand it.
Okay, because the point I would like to make is just that does then create a different passing score for reciprocity considerations. Usually, if you have a single national exam that all states use, you typically want to use their recommended passing score. Otherwise, it then has differing expectations. I just wanted to make that point. Thank you.
Thank you, Tracy.
And Justice Guerrero-Leah unfortunately had another commitment that required her to step out of the meeting. So
okay. Then I'll circle back with her later and move on to the next steps. I wanted to thank all of the presenters and all of you here today for your excellent questions, and trying to figure out how to move forward consistent with the objectives that we outlined at the beginning of the meeting. One thought that we had a group of us discussed and I wanted to raise with you is basically breaking up into two subgroups that would have different areas of focus along parallel tracks, so that one group would primarily consider a range of feasible alternatives to a bar examination in California. And some of those we touched upon today. Some may not fit California, but that would be an area that the subgroup would explore. And then the other two primarily consider modifications that can be made to improve upon the existing general structure of a bar examination. So as examples, modifying the types of questions. So one thing that could be done that was alluded to earlier is emphasizing performance tests more than multiple choice questions, or providing more time that's allotted to complete the test so that it's more realistic measure of minimum competence, open book options, etc. So those would be the two general parallel tracks, and each subgroup would then meet separately and reconvene to present the results of their discussions to the larger group. So there would be one meeting for each subgroup, and then the following meeting would be like this with the entire group and presentations from the respective groups provided to the entire group. In order to accomplish that, I would want to get some general preferences that you would have, so that I'll ask, I think in a survey format, what your preference would be as to which subgroup you would prefer to work on. Although we couldn't guarantee that that would be where you would end up, because we'd want to make sure that the selections are made with a goal of making sure that there are different viewpoints and experiences that backgrounds that are on each group. So if everybody picked one group versus the other, then we'd have to make some adjustments in terms of selections. I just wanted to open that up for any feedback that you may have, and then we'll provide additional details going forward. It looks like Jackie has a question. Jackie?
Yeah, just a clarification, Justice. Thank you. The group that would be considering modifications of the current exam, is that group assuming a California created, California-based exam, or is it also incorporating a potential next gen as an option in their considerations?
I mean, that's a great question. It's sort of like difficult to make that decision without really knowing what the next gen will be. But that would be part of what that subgroup would consider. I think probably it would make some sense to envision it as a California only. I think it's easier to say we'll go along and pick next gen, but it may be more valuable for the group to have some consideration and concrete ideas on how to format a California alternative. Any other questions or feedback on that general approach? And I'm open to other ideas. I just thought that it might be the best use of the group's time going forward. I see some nodding, so I'll take that as agreement.
Yeah, Justice Pereira, I'd like to, I guess, echo what I think is Jackie's, in part Jackie's question. I think it would be helpful if part of the scope of that second subcommittee that you described is sort of based on what we know, UBE versus California, and then because the subgroup will only be making a recommendation to this group, to the full group, that they also proceed with and if California, then
yes,
here would be the components.
Yes, exactly. I do want to get to that point, definitely. Well, I do see general agreement. Is there any disagreement? Okay, I don't see any. And I don't know if anyone else has any additional thoughts. Donna and Amy and Neil, I should ask you also.
It looks like Susan has her hand up.
Oh, Susan, I'm sorry. Susan?
Thank you, Donna. Just a quick question. One of the presentations today from Wisconsin tipped on an issue that I'd like to hear more about, and maybe in a subgroup or maybe in a collective meeting. She discussed the discipline rates and that lawyers subject to diploma privilege were not disciplined at a higher rate, and that competency is less than 1% of their discipline matters. I wonder, because California has its own provisional licensing program that's been in effect now for a while, that we might have an ability to look at some preliminary data to see if we are having disciplinary complaints arise out of it, if they are different than the disciplinary complaints that are arising for our normal young lawyers subject to examination, or if they are the same, or just basically if there's any data at all that we might take away from the preliminary, sorry about that, from the preliminary licensing that we're doing right now in our own state.
Thank you. And that definitely is a topic that we've had in mind to get additional information on. And Neil, I see you have your hand raised and you may have additional information for us.
No, actually, on that point, I actually don't. But just another suggestion or idea or alternative. I mean, I'm not saying maybe to do this now. Obviously, it's almost 4:25 or 2 minutes away. But I feel like maybe there'd be some value if this group had a group discussion first before we decide to maybe split off into groups. I mean, just to sort of read the temperature of where everybody is and what our thoughts are. We really haven't had that chance. And so just coming from me, a suggestion that maybe at the start of our next full meeting, we have that kind of discussion.
Okay, yeah, I do think that it's a little bit difficult. It has been, I think, from my perspective, the format, and I wish that we were in person. I
It
think
would
that
help, yeah.
facilitate the discussions, but
Yeah.
we're where we're at. And I do think that's a good idea. We've been cut off a little bit, and I know that we have more questions on some of the presentations that we might be able to ask if it were a different format. So yeah, thank you, Neil, for that. I think what I'll do is, why don't I circle back, Neil, with you and Donna and our subgroup and Josh and a few others, and we'll discuss next steps from here. I think in the meantime, I'll go ahead and at least get started, and we'll send out a survey just to solicit preferences for the subgroups. So at this point, I'm not sure when the timing will be, but we'll at least get the ball rolling on that and then have sort of this discussion group. I think the time to be determined at this point.
And Justice, if I may add, that maybe at our next meeting, we invite Oregon back to do their.
Oh, definitely. Yeah. They will be invited back at some point, and they've done all the work, and I wouldn't want it to go to waste. Ryan, you had a question?
Yes, I wanted to know if we were going to vote to approve the mission statement.
I think that there's probably more work that we need to do, given the feedback. That was just my sense.
Okay, that makes sense. Thanks.
Any other questions? So we're right at 4:25, but it sounds better than it is because we didn't have Oregon.
I have a really quick question, if all possible,
Yes.
Justin.
Yes.
So you mentioned that the survey, and I may have missed this, forgive me, but you're sending a survey about subgroups. Is it possible to just poll us about what we're thinking about, what we might want to do with the exam, an alternative exam, et cetera? Or is that, I mean, I know I agree with Neil. I like having the group discussion, but it might be good to have something to discuss if it's survey results of the commission or something like that. So just a thought.
Okay, yeah, we'll try to develop something that might facilitate our discussion. Thank you.
Yeah, I mean, I think I'd be reluctant to survey folks on sort of where they're sort of coming down by email, and how that might conflict with our Bagley-Keene open meetings requirements. Though I was thinking, Emily, sort of along those lines. I mean, in our last, well, now we're in the negative minute time, but there's without sort of a discussion, just based on everything that we've heard, we could certainly, just by a show of hands, no motions, no anything, but just take a straw poll just to see where folks are on sort of the where does the commission think it may be leaning based on the information we have right now, knowing that it's not complete, on sort of the key question of UBE versus California exam, and also then the question of exam, do we do an exam at all, or are we only looking at exam alternatives? And that's an option if we wanted to do that, if we didn't think that would what's the word I'm looking for? Sort of create sort of too much, force people into a position that they're not comfortable with right now, right? We don't want to taint anyone's thinking in any future discussion on it, but it's certainly an option just to do a show of hands.
Tracy has her hand up.
I like going back to Neil's suggestion, is just having a conversation, and maybe in that conversation, each person could maybe discuss where, their thoughts about where they're going, because I really personally have kind of a hybrid thought of things. It's not, just an exam or just something different. It's more of a hybrid approach. So I don't know how that would fit with the polling. Thank you.
Yeah, maybe everyone could think of what, in an ideal world, what they would want as the ideal or the admission process to look like, and we can just have that discussion at the next meeting. Okay. Well, the meeting business has concluded at this time, unless there is any additional business. I want to thank you all again, and at this time, the meeting of the Blue Ribbon Commission is adjourned. Thank you.
Thank you, Justice. Great meeting today.
Thank you.
Thank you.